Donald Trump made a "my lips are sealed" gesture outside his civil fraud trial today, but he was anything but tight-lipped on the stand.
Extraordinary tension inside that courtroom, with Donald Trump really pushing and pushing and pushing the judge.
Trump sure looked ready for a fight as he glared at the camera. He clashed with Judge Arthur Engoron from the moment he took the stand, giving long speeches instead of yes and no answers. "This is a very, very unfair trial. Very," Trump complained. "Control your client," the judge told Trump's attorneys. "If you can't, I will." He even snapped at lawyer Alina Habba, telling her to sit down when she insisted maybe he should listen to Trump's long-winded rants. She hit back outside the courthouse.
I was told to sit down today. I was yelled at, and I've had a judge who is unhinged slamming a table. Let me be very clear. I don't tolerate that in my life. I'm not going to tolerate it here.
What millions just watched inside that Manhattan courtroom was the raw, unfiltered collision between Trump's carefully constructed mythology and cold, hard reality. For years, he has been telling his supporters that he dominates courtrooms, that judges bend to his presence, that his legal battles are showcases of his strength and command. Every single piece of that narrative collapsed the moment Judge Arthur Engoron looked down from that bench and decided that the standard rules of American jurisprudence were going to apply in his courtroom, regardless of who the defendant happened to be.
Things got so heated that less than an hour in, the judge called for a 15-minute recess in an attempt to cool things down. But when Trump came back, his attitude was unchanged. He called the attorney general a fraud and the entire trial a political witch hunt.
Because it's a scam.
When he was done testifying, he declared the day a win for him.
You saw what I had to say today, and it was very conclusive. Everything we did was absolutely right.
He may feel emboldened by bombshell new polls that show him beating President Biden in 2024.
New polls are showing some very unfavorable trends for President Biden.
A New York Times Siena College poll shows Trump leading in 5 of the 6 most important battleground states.
The polls are rattling many top Democrats, including former Obama advisor David Axelrod, who says Biden should reconsider running.
He just has to ask himself, is this the best path?
CBS News chief election and campaign correspondent Robert Costa. Are there alarm bells going off in Washington right now? How are Democrats reacting to these poll numbers?
Democrats are not happy with these poll numbers, but at the same time, nobody is looking to push President Biden out. At this point, it's going to be President Biden's decision about what he wants to do with his own future, and everyone close to the president tells me he's in this race and he's not getting out.
What followed was not dominance. It was not command. It was a spiraling meltdown that ended with the judge telling Trump's own attorney to get his client under control and then cutting him off entirely and bringing the gavel down on the whole spectacle. Let me set the stage properly, because the context here is essential for understanding why this confrontation mattered as much as it did. This was the closing argument phase of the New York civil fraud trial, the case that struck directly at the heart of Trump's carefully cultivated business persona. The allegations involved systematic inflation of asset values, the kind of financial misrepresentation that built the Trump brand over decades and ultimately propelled him to the White House.
Former President Donald Trump has taken the stand in the $250 million civil trial that threatens his sprawling business empire. The case centered around accusations that Trump, along with his 2 adult sons, inflated various Trump assets to get more favorable rates from banks and insurers. Trump and his children have denied any wrongdoing, and while Trump just took the stand about an hour ago, the judge has already accused the former president of treating this appearance like a political rally. The judge has urged Trump's lawyers a number of times to control their client. Let's go right to NBC's Vaughn Hilliard outside the courthouse. Vaughn.
A judge had already ruled in a written pretrial decision that Trump, his sons Don Jr. and Eric, and the entire Trump organization committed extensive and persistent fraud over a decade. The stakes were not just financial. They were existential for a man whose entire identity rests on the proposition that he is a genius businessman whose net worth is exactly what he claims it is. Trump wanted to deliver his own closing argument. That was his demand going in. He wanted to stand before the court and address the judge directly through his own voice, rather than through the careful procedural mechanisms of legal representation. The request itself was unusual. Defendants in civil trials do not typically deliver their own closing statements. That is what lawyers are for. But Trump is not a typical defendant, and his legal strategy throughout these proceedings has consistently blurred the line between courtroom advocacy and political theater. Judge Engoron was willing to consider it. He did not reject the request outright, but he imposed a condition, the same condition any judge would impose on any defendant seeking to address the court directly. Trump's legal team had to promise their client would stick to the law and the evidence. No campaign speeches, no political rants, no new material that had not been presented during the trial. Just the facts of the case and the relevant legal standards. This is where everything began unraveling before Trump ever opened his mouth. His lawyers would not make that promise. Think carefully about what that means. The attorneys representing a former president of the United States in a civil fraud trial, offices of the court bound by ethical obligations of candor and professionalism, could not assure the judge that their own client would follow basic courtroom procedure if permitted to speak. They knew what he was going to do. They knew he could not contain himself within the boundaries the judge had set. And rather than give their word and watch him break it, they refused to give their word at all. The judge denied the request. The lawyers would handle the closings as lawyers do in virtually every civil trial in virtually every courtroom in America. That should have been the end of it. It was not. Attorney Christopher Kise rose and asked the judge once more to let his client speak. A second attempt at something already denied. A procedural Hail Mary that put the judge in the position of having to engage directly with the defendant about what he would and would not be permitted to do. Judge Engoron turned directly to Trump and asked him whether he would follow the guidelines that apply to every closing argument in every courtroom in this country. Trump's response was immediate, and it was not an answer to the question that had been asked. He launched straight into a tirade about political witch hunts. He announced he was an innocent man being persecuted. He declared the entire proceeding was a fraud on him, and then, in a moment of pure, unfiltered condescension aimed directly at the man wearing the judicial robe, he looked at Judge Engoron and said the words that will follow him through every remaining legal proceeding he faces. I know this is boring to you. Sit with those words for a moment. A sitting judge presiding over a complex civil trial, being told by the defendant that the proceedings are boring to him, as if the judge were a student nodding off in a lecture rather than a judicial officer exercising the full authority of the state of New York. The condescension was personal. The dismissal was direct, and it was aimed at the one person in that room with the power to shut the entire performance down, which is exactly what happened next. Judge Engoron did not debate him. He did not engage with the substance of the rant. He did not try to reason with a defendant who had just demonstrated he had zero intention of being reasonable. He turned to attorney Christopher Kise and delivered 4 words that every lawyer in that courtroom understood immediately. Control your client. Not, please speak with your client. Not, perhaps your client might benefit from a brief recess. Control your client. The implication was unmistakable. The judge had identified a situation spinning beyond the bounds of acceptable conduct and was placing responsibility for reining it in squarely on the attorney whose professional obligation it was to do so. Then he imposed a time limit, 1 minute. Trump had 1 minute remaining before the court would break for lunch. 1 minute to wrap up whatever he thought he was accomplishing. 1 minute before the gavel came down and the defendant, who had spent his entire public life insisting he could talk his way out of anything, was told his time was simply up. When that minute expired, Engoron cut him off and recessed the court. The proceeding ended because the defendant had made it impossible to continue without compromising the basic standards of order that American courtrooms require to function. What happened next is just as revealing as what happened inside. Trump had a choice. He could stay for the afternoon session. He could demonstrate that despite the confrontation and the shutdown, he respected the institution enough to remain present. That is what defendants in ordinary cases do. They stay. They sit through the parts that are not about them. They show the court they take the process seriously, even when it does not go their way. Trump did the opposite. He skipped the afternoon session entirely and walked to a nearby building he happens to own, stood in front of cameras he controlled, in a setting he controlled, and proceeded to attack everyone connected to the case. Judge Engoron, Attorney General Letitia James. The news conference was the courtroom rant continued by other means, a political counterstrike designed to reframe the day's humiliation as righteous indignation rather than the procedural defeat it actually was. The pattern here is not subtle, and it is not accidental. When the courtroom imposes limits, Trump seeks a more favorable venue. When judges demand compliance, Trump attacks the judges. When the gavel comes down, Trump finds a microphone and an audience that will not cut him off after 1 minute. The sequence of courtroom to news conference, judicial accountability to political counterattack, has become so familiar it constitutes its own genre of Trump legal strategy. But the strategy has a fundamental weakness that this confrontation exposed completely. The judge controls the courtroom. The judge decides when the defendant speaks and when the defendant stops. The judge can direct attorneys to control their clients. The judge can impose time limits and recess the proceedings. None of that power is subject to appeal in the moment. The defendant either complies or faces consequences. And on this particular day, the consequences were public, visible, and humiliating for a man who has projected invincibility for 50 years. The broader context of Trump's relationship with the judiciary makes this shutdown even more significant because it is not an isolated moment. It is part of a documented and escalating pattern of attacking judges who rule against him that extends from the lowest trial courts to the Supreme Court itself. He has called judges lunatics. He has called them monsters. He uses the catch-all label of Trump deranged to dismiss any ruling that does not go his way. He has turned every court loss into a fundraising email and rally material in a way no previous American political figure has attempted at anything approaching this scale. And perhaps most revealing of all, when the Supreme Court ruled against his tariff powers, he did not respond with measured disappointment or respect for the court's institutional role. He blasted the justices as a disgrace. He said he was absolutely ashamed of them. These were his own appointees, judges he personally selected and elevated to lifetime positions on the highest court in the country. When they exercised independent judgment in a way he did not like, he attacked them with the same language he uses for political enemies. Think about what that communicates to every judge in the federal system. The message is simple and corrosive. Loyalty to me is the only standard that matters. Rule against me and I will attack you, regardless of your qualifications or your reasoning or your relationship to my own administration. That message echoed through every moment of the Engoron confrontation because it establishes the baseline from which Trump approaches every judicial interaction. He does not walk into courtrooms believing judges deserve respect by virtue of their office. He does not accept procedural rules as legitimate constraints on his behavior. He views the courtroom as another arena for political combat, and the judge as either an ally to be cultivated or an enemy to be destroyed. The skills that built his political career, the improvisational rhetoric, the personal attacks on perceived enemies, the willingness to say things traditional politicians would never say, are the exact opposite of the skills that function in a courtroom. Courtrooms demand precision. They demand adherence to evidence. They demand respect for procedural boundaries. A defendant who treats a judge like a political opponent and a trial like a campaign event is a defendant who is fundamentally incompatible with the requirements of the legal system. And the control your client directive, the 1-minute warning, the shutdown and recess represent the institutional answer to that incompatibility. The institution says there are limits. The institution says the defendant does not get to run the room. The institution says that when behavior crosses a line, the proceeding stops. The American legal system does not run on rules alone. It runs on a widely shared cultural belief that the rules are legitimate and that compliance is not optional. When a prominent defendant demonstrates repeatedly that the rules can be defied without meaningful consequence, that belief erodes. Every time a courtroom gets turned into a rally venue and the defendant walks out to raise money off the confrontation, the system loses a piece of the cultural authority that makes it work. What the Engoron confrontation ultimately represents is a test of whether that authority still has force. The judge imposed limits. The defendant resisted them. The judge escalated. The defendant retreated to a more favorable venue. The institution held its ground for the length of a single court session. Whether it can continue holding its ground across the many sessions and confrontations still ahead is one of the most consequential open questions in American public life right now. The underlying dynamics that produce this confrontation, the defendant who refuses to accept procedural limits, the judge who insists on enforcing them, the political movement that rewards defiance with donations and loyalty, are all still fully in place. The next courtroom confrontation is not a question of if, it is a question of when. And when it arrives, it will test once again whether the institutional architecture that held steady in that Manhattan courtroom can continue holding steady against everything still coming at it. Because the fraud finding is permanent, the pattern is documented, and the legal exposure does not disappear when the news cycle moves on to the next outrage. Drop a comment and tell me what you think. Does this pattern of courtroom defiance eventually produce real, lasting consequences, or does Trump keep converting every judicial shutdown into political fuel indefinitely? Hit the like button, subscribe, and ring the bell, because we are covering every development in these cases as they unfold. See you in the next one. Stay safe.